What follows is a year-long account of what you might find to be an unquestionable campaign of harassment by TV licensing against one of my viewers, which really infuriates me because I created all of these channels to try to help you to understand law, to avoid breaking the law where you can. But when people are repeatedly threatened with prosecution or further investigation, visits, and all sorts of other things, I find that oppressive. I find that unacceptable. And in many cases, that might cross the threshold into harassment. And there is one such case which I'll discuss with you in this video and compare and contrast and say why I think the culmination and the collection of these letters may well amount to harassment. Now, this video talks about two of my viewers, one of whom sent me what I think is probably the worst example sent by TV licensing in its recent campaign that I've ever seen. And I think that unquestionably, in my opinion, unquestionably crosses the threshold into what someone absolutely should not put up with. And I won't let you put up with it. So we're here on Black Belt Secrets. Do keep this channel growing. We're well over 200,000 subscribers now. Wouldn't it be funny if this reaches 1 million before my main channel, Black Belt Barrister, which is getting closer, 904,000 over there now. So thank you all so much for that. But let's go first of all to the opening. I'm going to show you the opening to this email from one of my viewers. Anonymized, of course, but it really encapsulates just how frustrated my viewer is. And it opens as follows. Hi, Daniel. Like many others, I receive monthly threats from TV licensing agency, whilst I'm aware of no obligation to notify them that I do not need a license. If it wasn't for channels like yours, thank you very much, then I would absolutely believe the threats of enforcement they send as an intent to have an enforcement officer come around. It's in quotes because they can't enforce anything unless, at the very least, unless they've got a warrant. And if it's a fine and they've got a writ or a warrant of control and so on, they can't enforce anything. But if they didn't watch my videos, they would believe these threats that these enforcement officers would come around, and I would not be clued up, my viewer says, to the fact that they have no actual powers, absence a warrant, and would likely feel that I have to answer their questions. Since watching such videos, I've noticed the very ambiguous language they use to skirt the line between getting someone to believe they will prosecute them and the legal deniability. We didn't actually say that they might use as a defense should someone take legal action against them. But I think they are getting to a point where that would fail. More about that in a minute with the case law, which it has been held that threat of litigation can amount to harassment. It's only a question of time before someone actually sues them. And I will help, and I won't charge anything for it. What I've received is typically the same stuff everyone gets. Will you be in on X date? They never show up. How disappointing. Investigation opened, unlicensed property, 10-day window, enforcement visit approved, and so on, my viewer says. It's rather interesting to see the variety of vague threats that they have if you have a few months of these things saved. I'm pretty sure they just pick them at random and send them out. It makes them more official if they send different letters out and makes it look like their investigation is actually going somewhere. And then there's a middle chunk explaining what's happened and so on. And then the final concluding paragraph of my viewer's email really encapsulates to me. Let me know in the comments if you feel like this, because I suspect a lot of people feel exactly this way. And says, just to point out, I do find these letters threatening and harassing. It's only because of people such as yourself that I'm aware that they have no power, so long as I don't watch live TV or the BBC, and that I don't take the letters too seriously. In other news, it might alarm you to hear that it was recently revealed that Ofcom, the UK's regulator for communications and all stuff online and broadcasting and whatever, has spent nearly £500,000 on internet monitoring software and services and tools to essentially spy on people since 2022. That excludes this current financial year, as I understand. This was a result of freedom of information requests submitted by Tech Radar. They wanted to know how much they spend on tools to spy on you. So if you don't like being spied on and there's something you want to do about that, I can wholeheartedly recommend that you subscribe to NordVPN, which is an internet privacy tool, which I originally paid for with my own money. I used it happily, and knowing that I was that little bit safer when I'm browsing the internet, they since partnered with me and sponsored my channel. I now consider myself an ambassador. I work with them on all my channels, and I am very pleased to do so because I genuinely think that it brings you a safety and security net that you really need to sign up to. It will give you an anonymous IP address so they can't track where you are. NordVPN does not keep any logs, despite what some people think, so they won't keep any logs of what you're doing online. NordVPN will scan websites that you visit for malicious code and tracking codes and things like that, malicious websites, malicious downloads, and flag those to you before they become a problem. NordVPN also scans the dark web for release or leak of your information so you can do something about it. And if you are worried about that, there is a Nord Protect, which is an all-in-one identity theft protection service available from Nord Security, which you'll find linked below as well. And as they're a partner to my channel here, use my code BlackBeltSecrets for 4 months additional free off their 2-year plan, which is an absolute no-brainer for less than the price of a cup of coffee for that privacy shield, giving you that peace of mind. So don't forget the code BlackBeltSecrets. I'll link it below so it's easy to go for you. And thank you to NordVPN for sponsoring this channel. If I had the just because I can money to take them to court about it, I would. The Local Government Association website states the following. The main goal of harassment is to persuade victims either not to do something that they are entitled or required to do, or to do something that they are not obliged to do, which certainly fits the vaguely threatening enforcement letters every month until you either give them your personal details and notify that a license is not needed or pay for one. And that certainly fits that to a T. This is my viewer's opinion here. I understand that there is a statute or such that lets them enforce the license, but I take photos from time to time. They are my photos and I have the right to enforce the copyright on them. I don't have the right to threaten every UK citizen or demand that they prove they don't use them or have me pay a license. That's a very valid point. Just because someone has the copyright, you can't email anyone endlessly and say, you must pay for a license if you want to see my photograph. That's not how it works. So let's get into some of these letters, because this goes all the way back to December 2024. And I'm sure many of you have had a letter like this every month on the dot, just round the clock, round the calendar, and sending these threatening letters out. Now, if we were to look at this from a legal perspective as a campaign of harassment, let's just consider. What we'd need to consider is, if we were a court now, let you be the judge. You be the judge. Let me know in the comments if you just think, just put wrong or something that makes it clear in the comments that you think this letter is wrong. Now, what would be acceptable is TV licensing sending out a letter just to say, just a reminder, if you don't have a TV license and you watch live TV or you record live TV or use BBC iPlayer, you need a license. And just a reminder like that, that'd be a perfectly reasonable thing for them to do, to remind you every now and then. That sounds fine. But the reason I object, the reason so many people object, is that they really are threatening letters. So be the judge. If this crosses a threshold that ought to be liable in harassment, which is there's more than a reasonable person should be expected to bear. There's ample case law on harassment. We can go through that in another video, but it's just understood to be more than a person of reasonable firmness should be expected to bear on a daily basis. So, if you've got a neighbor that says hello to you every morning, it might get annoying after a while if you don't like it, but that's not harassment. If you had someone leave something horrible at your door every morning, that's harassment, because it's more than you're supposed to be expected to bear, if that makes sense, yeah? Let's take a look at these letters one by one. Officers have now been authorized to visit address. Now, any person of reasonable firmness would understand that to mean they are going to get an officer of some sort visit the address. Bearing in mind this is back in December 2024. So is that more than you should reasonably be expected to bear? Let me know in the comments what you think. And then it says, as this property is still licensed, your details have been sent to the enforcement team in your area, and we're authorized to visit to this address. You could be prosecuted, etc., etc. Now, important to bear in mind that one of these letters may by itself not cross the threshold. But if more than one of them taken together cross the threshold, that could be lumped up as one event, one course of conduct, or one part of a course of conduct. A course of conduct is at least 2 occasions that cross that threshold. So we can lump these things together. stronger if you've got one letter that you think crosses that threshold. So bear that in mind and let me know in the comments what you think. Next, will you be in on the 20th of February? Now, this is pinning it down to a date. This is a month later, January 25, pinning it down to a date. As there's no record of a TV license at your address, you should expect a visit from an enforcement officer. Now, this is important for reasons I'll come back to a bit later in the video, because they've set a date and they've said what will happen on that date. And that's important because now, from a legal perspective, they've made a threat to you. They've said, will you be in on this date? As there's no record, you should expect a visit from an enforcement officer on that date, presumably. But then they go on to say, it may be on the 20th or another day. And so they vague it up in this section here. But I don't accept that. I don't think a court would accept that because the big bold headline is 20th of February. You should expect a visit from an enforcement officer. Any reasonable person, let me know what you think. If you disagree with me, please do. But I don't think you will. Part of my job is to see things from an objective, i.e. not me or in one individual. What would an ordinary reasonable person think? Would an ordinary reasonable person think from this letter that you expect a visit on the 20th of February? Let me know in the comments. I think you would. And I think a court would accept that you would. They then vague it up and say it may be the 20th or another day. I don't buy that bit, but by the by. So this is important when we come back to it later, because this can amount to a harassment letter if they don't visit, in my view, because they've threatened you that they will visit. And if they don't visit, that then means this could amount to harassment for reasons I'll explain later in the video. And yes, I get one or two people complain, oh, you always say later in the video. Yes, I do that sometimes. I will come back to it. I always come back to it. And there's a reason to come back to it because it applies to more than one thing. Next, this is now February, a month later. Round the calendar, these letters come out. Official notice, investigation opened. Now, that is enough for anyone. It's coming out from an official organization, TV licensing, and says official notice in big bold letters. Doubtless some of them come in a red envelope or a brown envelope or whatever, so it makes it look more serious. We know the tricks. We lawyers know the tricks. And it says official notice, investigation opened. Now, if an investigation has been opened on the 27th of February or recently before, you should expect that that will proceed or go through the process and come to a close. But as I said, this was over a year-long campaign. So February, they said the investigation's opened. How you can stop it? Buy a license or tell us you don't need one. There's no statutory obligation to say that you have to tell them that you don't need one. So from my perspective, again, let me know as we go through, if you agree with me in the comments, for them to say you can only stop this investigation by buying a license or telling us you don't need a license. Now, that should not be the case. That is unreasonable because there's no statutory requirement to tell them that you don't need a license or to buy a license for that matter if you're not watching or recording live TV. There's no common law duty for that matter to tell them that you don't need a license or whatever. So that being the case, I personally think it's unreasonable for them to give you an either or, buy a license or tell you don't need one. I think that's unreasonable. So this letter, I think, crosses the threshold. If indeed, this investigation has really been opened, and they'd have to, if it went to court, they'd have to prove that it really was opened and that something changed, comparing to the month or a couple of months before and afterwards, they'd have to show that something actually changed. And if it didn't, then again, it might come back and bite them. Next, March. You've not responded to our letters. You've left us no alternative but to proceed with the final stages of our investigation. So this suggests that something happened between February and March. Again, if it went to court, they would have to show what happened between February and March. I suspect nothing happened. I suspect they just sent another letter out. If they really didn't do anything, again, for the reason I'll come back to in the case law that I'll show you, then again, they could be held liable in harassment. Because if they didn't do anything, why did they tell you they opened the investigation? And why have they told you in this letter that they're proceeding to the final stages of the investigation? But then it goes further and says, an officer's been scheduled to visit this address to find out if TV's been watched, recorded, or downloaded illegally. So what, they're going to spy on you? That's beyond reasonable, to say the least, because how are they going to come and find out if you're watching TV without coming into the home? Well, they can't come into the home without a warrant. So how are they proposing to do that? Because they can't do that. Without a warrant, they can't do that. Let's be absolutely abundantly clear. There is no statutory or even common law power for them to enter your premises to check whether you're watching TV or whatever illegally. Now, I don't condone breaking the law. Whether I agree with the law or not is another thing. I don't advise you to break the law. I don't agree with breaking the law, whether I agree with the law or not. There's a fine distinction. But to tell you that an officer has been scheduled to visit, to find out if you've been watching TV, the only way they could possibly do that is by breaking into your house and then checking, which they can't do without a warrant because there's no statutory or common law power for them to do so. And so this is an empty threat, really, but it is an official empty threat, which for me crosses the threshold and for me makes that another course of conduct, part of the course of conduct for harassment. So I think that crosses the line. And then again, it says, visit undertaken by our enforcement team. Please ask for identification, blah, blah, blah. And again, in this letter, it's threatening you with an enforcement team visiting. Not that they're actually enforcing anything, but that's what they say. That was March 25. Moving onwards, April, another month later, official notice this time, as though any of the others weren't official. Please read carefully. You are breaching the Communications Act 2003 if you do not have a TV license to cover you for. Now, this is wrong, frankly, because you need a license if you do watch or record live TV. But this says you are breaching the Communications Act if you do not have a TV license to cover you for this at this address, which again, reading that plainly, it says you're breaking the law if you don't have this that covers you for that. Well, if you don't do that, I watch, record live TV, then you don't need that. Therefore, you're not breaking the law. But they don't say that. So I think this is badly worded at best, and I think it's deliberately misleading at worst, which again, 50-50, really, whether a court crosses the threshold here to say that that amounts to harassment. We've still no record of a license at this address, no option but to continue with our investigation. So now, having previously said it's the final stages of the investigation. Remember, if we go back to this previous letter up here in March, proceed with the final stages of the investigation. Now they've said, well, you've left us no choice but to continue the investigation. So now they've given themselves an out and said, actually, we're going to continue sending you these threatening letters. If enforcement officers find evidence of illegal TV viewing, which I don't see how they can, by the way, without breaking into your home or looking through a window. And by the way, I don't agree that they'd be allowed to look through a window either. They don't have implied license to approach your window. I think that would be a breach of privacy, quite frankly, because they've got no idea what you're doing inside that house, and it's none of their effing business, to be quite frank with you. So they shouldn't be approaching a window. They only have implied license to approach your front door, and even then you can revoke that with a template letter, which is on my Black Belt Barrister Pro, which I'll link below. You could be interviewed under caution or in accordance with national criminal law. This could lead to prosecution, etc. And to stop a visit, buy a license or tell us you don't need one. Now, again, giving you an ultimatum, buy a license or, fess up your details and tell us you don't need one. I think that is wrong because there's no, as I've said, there's no statutory obligation. There's no common law obligation to tell them that you don't need a license. So therefore, I think this crosses the threshold for two reasons. One, it says that they're going to continue with the investigation that they've already told you was coming to a close. And secondly, they're giving you an ultimatum, which I think is unlawful. It says you must buy a license or tell us you don't need one to stop the visit, which I think is false. I don't agree with that. Next, it goes on. May. I will speed up as we go through these because you've seen a lot of them before, but I'm commenting on them generally. 10-day window. Now, this is 2 months after they said they're in the final stages of investigation. A month after they said they're going to continue the investigation. Now they said you could expect a visit at any time, which I don't accept. I think that's unreasonable. Just say normally you could expect a visit at any time. Well, in the strictest sense, if they've got an implied right to approach the front door, that could be any time. But giving it a 10-day window and then said, your case is on hold for the next 10 days. This is putting pressure on you. And again, giving you an ultimatum. Buy a license or tell us you don't need one. You only have until the 11th of June before this window closes. Now, 11th of June and 10-day window, and this is on the 21st of May. So which is it? Is it 10 days from the 21st of May or is it up until the 11th of June? So that doesn't make sense anyway. That tells me that this is probably a mass-generated BS letter, which you should probably ignore. Next. June, it goes on. We did not hear from you in big, bold letters like that's supposed to be more. It's obviously supposed to be more threatening. This address is still unlicensed. We wrote to tell you that we're giving you 10 days to get correctly licensed, free from the risk of an enforcement visit. Now, to be clear, there is no risk of an enforcement visit unless they have a warrant, because they cannot come in without a warrant, and there's no other risk, because why would you be at risk? Why would they be telling you you are at risk? Again, let me know in the comments if you think that crosses the threshold into harassment. What you can expect now, it's been escalated to the enforcement team. You can expect a visit from an enforcement officer. And again, to be clear, they cannot enforce anything. An enforcement team, what are they enforcing? If this went to court, the court would say, right, where's your evidence to show that you escalated this to an enforcement team? And who's the enforcement team? What did you give them? What information did you give them? How was this case presented to an enforcement team or an enforcement officer? Or was this just a BS letter to threaten people? That's what I think it is, quite frankly. And then it says, act now to stop the visit and go and buy a license. Now, again, I don't accept that. July, will you be in on the 6th of August? And again, more of the same fluff. Again, in August, before it says are you in on the 6th of August, now it comes to August, 13th of August, official notice, investigation opened. Well, hang on a minute. Wasn't it February? Let's go back a bit. I'm sure it was February when it says investigation opened, back in February. And then it says, this is an official warning to say that we're carrying out an investigation. But then when we got to March, it said the final stages of the investigation. So now we come down to August, June, July, August. Now this says investigation opened. Well, which is it? I'd love to have these people on the stand in cross-examination for, if not, criminal harassment, at the very least civil harassment, and say, is it not right that you sent a letter in February to say that this investigation was opened? Yes. And is it not also the case that not within a couple of months of that, you said that you were entering the final stages of investigation? Would you not agree that if you are receiving a letter that says that you are in the final stages of investigation, that should be nearing conclusion? And so if it's nearing conclusion, it should be near an end, not near the beginning. And then isn't it also right that in August, you have sent out a letter saying official notice investigation opened? Wouldn't you agree that is contradictory with the previous letters that you sent out? Would you not agree that that is more than a person of reasonable firmness should be expected to bear? I would love to have that in a cross-examination. Then this goes on. Official warning that we're carrying out investigation. As opposed to what? As opposed to the previous ones? Were they not an official warning, an official notice of opening an investigation? And then it goes on. And then after August, we have September. Your IN 0100, whatever that's supposed to mean. This code has been issued against your address. We use it to target unlicensed homes like yours that require a visit from an enforcement officer. Bearing in mind this was going on since 2024. Now, again, I think this might cross the threshold. Each of these, and then official notice in October, read carefully, much the same as before. And then in November, another one of these. As you've not responded to our letters, you've left us no alternative but to proceed for the final stages of our investigation. Now, again, another brilliant cross-examination point. Isn't it right that you sent a previous letter many months earlier, which said that it was the final stages of investigation? And if so, isn't it right that this letter should not have been sent again because it risks imposing an unreasonable fear of prosecution in the recipient, which amounts to harassment, would be the case against them. And then it goes on. December, act now to avoid a fine of up to £1,000. Action required, which again is misleading because there is no action required. If you do not watch or record live TV and you do not watch BBC iPlayer, at the very least BBC content on BBC iPlayer, despite the fact they're now moving to YouTube, which is, see my Black Belt Barrister video for that, my thoughts on that. I think that's problematic, to be quite frank. But again, action required. No, it isn't, because if you don't watch, record live TV, etc., you don't need a license, and you don't need to tell them that you don't need a license. So action not required. That's erroneous. But it goes on. and then January. Now, this is one where, for me, there's this and another one. The next one I'll show you is from another view of mine. These two, I think, really do cross the threshold. So you only need really one of the previous ones and this one, because I think this, in my personal view, unquestionably crosses the criminal threshold. This says, be prepared for this investigation to lead to prosecution. In any reasonable-minded person, I think, let me know if you agree with me, I think any reasonable-minded person would think that that means you are going to be prosecuted. Be prepared for this to lead to prosecution. Most people will think you are going to be prosecuted. And then it says what to expect if you're prosecuted. Now, they will say that, we didn't actually say you're going to be prosecuted. That's what they will say, but I don't accept that. But that's what it says here. And then it says, it's a criminal offence to watch or record live TV without a licence, which is true, but that's irrelevant, really, if you're not actually doing those things. And then avoid prosecution, act now, as it says under here, to prevent an officer and the legal action, buy a licence or move your licence or tell us you don't need one. Neither of which are actually necessary, because you do not need to do anything if you do not watch or record live TV and you do not use BBC content on BBC iPlayer and you haven't installed anything to do any of those things, which is really left to those installing and whatever, then you do not need to do these things. But I think this one crosses the threshold. And the other one, which is from a different viewer entirely, is pretty much a similar thing, who cancelled the direct debit. You're about to lose your license. Now, the bit I've highlighted here, I think, in my view, unquestionably crosses the threshold. Let me know what you think. You be the jury here. You be the judge and jury, whichever you please, or both. I think this crosses the threshold. And it says, act now or you'll lose your license on the 31st of January. And then an unequivocal statement. After this, you'll be breaking the law and risk prosecution and a fine. Now, the and risk prosecution and a fine, I think they've really cocked this up, because the risk prosecution and a fine, they will say, we gave ourselves an out because we didn't unequivocally say you will be prosecuted. But that's not the point. The point is they've here, in my view, unequivocally told this viewer that they will be breaking the law. It's a bit like me saying to you, you are breaking the law and you risk prosecution for it. But if you haven't actually done the thing that I say you've broken the law for, that's quite serious. It's a bit like the police coming around and saying, you've broken the law by stealing this thing and you risk being prosecuted for stealing this thing. But as you know, in criminal law, you are innocent until proven guilty. If the police say you've broken the law by stealing this thing, you risk being prosecuted. Well, the whole point of a prosecution is to find out whether you are guilty of breaking the law. But so this statement here, however you read it and however heavily they think they caveat this phrase here, it is wrong. They say, after this, you'll be breaking the law and risk prosecution and a fine. That is entirely wrong. This, at the very least, in my personal view, crosses the threshold for harassment. Now, I promised you as to why these might cross the threshold into harassment. This is a case I've mentioned before, Worthington and Metropolitan Housing Trust Limited. A very brief background of the case. It was two individuals on a housing estate were accused of breaking the law, etc. And the housing association sent them letter after letter after letter, threatened them, with police action and threatened them that they're breaking the law, threatened an injunction and so on, letters, all this sort of stuff, but didn't actually follow through on those things. And the two individuals took it to court, and then the housing association appealed it. So this is a court of appeal decision. So it is a very authoritative case on what might amount to harassment. Now, litigation conduct, essentially, what this is. Litigation conduct, the sending of legal letters and legal threats, etc., can amount to harassment where it's unjustified. I've talked of unjustified threats of trademark infringement and stuff in previous videos. But this one here, these few pertinent bits of this case, they, as in the housing association, they asserted that they'd received evidence from him abusing residents. The letter concluded with the threat of proceedings for an injunction and or possession against the individuals in the case. On the same day, the association solicitors wrote to Miss Parkin in the case, demanding the immediate removal of CCTV camera, threatening legal proceedings if it was not removed. The claimant sought advice from a law centre, which wrote to the association, denying all the allegations. In December, the association's solicitors wrote to the law centre, stating that unless Miss Parkin removed the CCTV within several days, they used this CCTV to monitor the antisocial behaviour in the area. Then the association would apply for an injunction against her. And on December the 14th, the association solicitors wrote to the law centre reiterating the allegation against Mr. Worthington, the other claimant in the case, had recorded images of children, that this constituted a nuisance to other residents, but reserving their position as to whether legal proceedings would be taken. In February, Mr. Worthington was told that legal proceedings would not be taken, and in June, months later, Ms. Parkin was told by the association that proceedings would not be taken against her. So the two claimants here issued proceedings against the association for damages for breach of Protection from Harassment Act, i.e. harassment. And at trial, the circuit judge found that neither the claimant had breached the terms of their tenancy agreement, and that the proposed action against them had been driven by the estate manager, who had assumed that the claimants were guilty of antisocial behaviour and failed to carry out a proper investigation into the truth of the allegations against them. Sound familiar? So the manager, the estate manager, had assumed that they were guilty and failed to carry out any proper investigation. So likening with TV license, if they hadn't actually carried out any proper investigation, like they say they do, but they keep threatening you anyway, that might then make them guilty of harassment. So here, the estate manager carried out these threats without proper investigation into the truth of the allegations. And then the judge found that the CCTV of Miss Parkin had always been used lawfully for the purposes of security. He found that only a small number of the 80 signatories, because they had a petition against them, were in fact local residents and the rest were other people. And the judge found that the association sustained threats of legal proceedings. We will sue you. We will go to court for an injunction and all this sort of stuff. The sustained threats of legal proceedings were oppressive and unacceptable, and awarded the two claimants damages of over £4,000 each. So this is a clear case where this is a campaign of harassment, and in the appeal, the judge dismissed the appeal, and ultimately the two individuals were right, and it remained harassment. And so, again, just highlighting that a sustained campaign of letter after letter after letter, such as all of these here, you can see the length of these things going on. And I know some of you have got letters going back years, and some of you have shown me those before. Don't post them out to me. I've had them before, and I've had a stack of them. They are interesting, but then I have to destroy them securely and so on. Email by all means, but email remains secure. But for me, this is a sustained campaign of harassment. Not necessarily every single one would cross the threshold, but it only needs two. And one that crosses the threshold and a whole list of others that taken together might cross the threshold would mean two occasions where they've formed a course of conduct that amounts to harassment. And at some point, someone, somewhere, is going to sue them. It's not without its risk of adverse costs if they lose, but I'd be willing to throw my hat in there on a pro bono basis for the right case to assist, at the very least, in drafting some particulars against them and hold them accountable, because this has got to stop. So I'm on a bit of a rant about it, as you can probably gather, but I hope you found it interesting. Do let me know what you think about each of those letters in the comments below. We're on Secrets. I've been Daniel Shen Smith. Please do subscribe, and I'll see you in the next one.